Hi, welcome. I'm Michael Goldfarb, employment attorney and president of Holman HR. If you're a client, welcome back. If you're watching us for the first time, maybe you'll choose to become a client. This is another of a Holman HR video alerts where we try to impart in about 15 minutes some information on a topic of importance to anybody who's running a business or who's in HR. Today, we're going to focus on leaves of absence and the concept of a reasonable accommodation. I know all of you are going, oh my God, I hate this stuff. We all do. It's complicated, but there is a light at the end of the tunnel. There is a way to manage and get through these things. So let's start off by talking about the different most common types of leaves, okay, that you all are going to have to deal with. Mostly we're talking about if you're a company that is subject to the provisions of the ADA, the Americans with Disability Act, then you are going to have to take precautions to ensure that you don't discriminate against people based on a disability. That can come into play when people take medical leaves of absence and how you govern and handle those particular situations. If you're an employer that has 50 or more employees, now you're subject to some very specific leave of absence statutes. Many of you might be familiar with them. The most prominent of them is FMLA, also known as the Family Medical Leave Act. That is the federal law that gives every employee working in a company with 50 or more full-time employees 12 weeks, basically. I was going to say 3 months, but 12 weeks of unpaid leave for a serious health condition of their own or to take care of a family member. And that's the one that comes up quite often. Again, if you are an employer that meets the criteria, as well as an individual employee who is eligible for that kind of leave. So that's FMLA. Now there are numerous states that have their own permutations of FMLA. And for example, if you're watching in California, they have CFRA, the California Family Rights Act. That is a similar statute to FMLA, providing almost identical leave of absence provisions. However, here's a big difference. California's CFRA, unlike the FMLA, does not include as part of the medical conditions an individual can use as a basis for the leave, it does not include pregnancy. California has a separate statute called the Pregnancy Disability Leave Law, sometimes referred to as PDLL. In California, this is only California, for example, you can have an individual, obviously a female employee, taking pregnancy leave. That means that either there is a condition during pregnancy, delivery, or recovery from delivery that a medical practitioner says, no, this woman cannot work, she needs leave under that law. That law gives them up to 4 months of unpaid leave. And in California, a female employee could conceivably take a full 4 months of pregnancy leave and then an additional 3 months or 12 weeks under not FMLA, but CFRA. That's because, some of you may know this, a person on pregnancy leave in California is taking pregnancy and FMLA at the same time. They run simultaneously, and then, if need be, and that, for example, female employee might want to bond with that newborn, then she can take an additional 3 months under CFRA for a total of potentially 7 months. So we've talked about the ADA, we've talked about FMLA, we've talked about one particular state's own version of these called CFRA. Other states have similar laws. Hawaii has a pregnancy leave law. So you need to look at your particular state and see if there are other laws that that will interact with this. In addition, we also want to remember that an employee on workman's compensation leave is almost certainly someone who's also simultaneously going to qualify to be on a disability leave like FMLA, CFRA. They're all going to run at the same time. Think about it. If I'm on a workman's compensation leave for a physical injury, albeit I sustained at work, chances are that that will substantially limit a major life activity of mine, correct? Now, I'm subject to the ADA as a disabled employee. I have a condition that qualifies as a work comp injury. I have something that would almost guaranteed be classified as a serious health condition. So now I'm under FMLA and the state equivalents like CFRA. So I can be on work comp, and at the same time I'm also under all these other leave statutes. They're all running at the same time, and the trick is for you as HR or an employer is to understand that they all carry significant but different implications, both from a notice standpoint and so forth. So really important to remember that. And lastly, there's one other nuance with leaves of absence in terms of the types of leave of absence that you have to be concerned about. And that is, let's say you're an employer that's too small, you're under 50, but you're over, you're 15 or over, so you fall under the ADA, and you have personal leaves of absence. Well, if you allow personal leaves of absence and someone in your company takes one for a medical condition, now you too have to be aware of the issues that I'm going to be discussing right now, dealing with reasonable accommodations and discrimination, because as an employer subject to the ADA, albeit not the particular leaves like FMLA, CFRA, or whatever, you still are subject to disability discrimination. And any employer, matter of fact, even if you don't have a prescribed policy, can find themselves in a heap of trouble. Well, what are we talking about when we say a heap of trouble? Well, first of all, let's talk briefly about what the ADA, the Americans with Disability Act, the requirements it imposes on an employer. The main requirement, especially since 2008 when it was amended, is that the main thrust of an employer's responsibility under the ADA is to enter into an interactive discussion with the affected employee to determine if a reasonable accommodation exists. Sounds easy enough. Well, what's a reasonable accommodation? Most employers automatically think that when we say reasonable accommodation, we're talking about changing the setup, making the workstation more ergonomically effective. That could be a reasonable accommodation. But more often than not, what we're talking about is a leave of absence. We're actually taking time off work to heal and get better is considered a reasonable accommodation. Now, it's certainly an accommodation. What's going to determine its reasonableness is whether or not you, the employer, can manage to do this without incurring such damage to your business, to the department, that it would constitute an undue burden. If that's not the case, and it's highly unlikely it is, because undue burden is a very high standard, well then the leave of absence must be granted as a reasonable accommodation to allow the person to recover and get back to work. That's the protection afforded by the ADA. And most employers forget that. When do they forget that? Well, it ties back into what we were talking about under the types of leave. When someone is granted, let's take the example of somebody on FMLA leave, and let's just say they were on, it wasn't intermittent, it was, you need 12 weeks, we'll give you 12 weeks, okay? You've given them the notices, they know they're due back after 12 weeks, they've given you the medical cert, everything is copacetic, they're fine, everything's good. 12 weeks roll around, the due date for them to return to the office comes and goes, they're not there. Typical scenario, employer says, I want, this person's done. They have voluntarily abandoned their job. Now, technically, yeah, they have. technically you're due back, you're not back, we notified you when you went out on leave, then we notified you again and reminded you when you were out on leave, and you're still not back. You have voluntarily terminated your position according to company policy. Well, what if that individual says, I can't come back? My condition isn't healed yet. What's your responsibility now as an employer? Is it over? Can you just say, sorry, time up, you're due back? No. And thank you for playing. You cannot do that. That's specifically where the protections come in under the ADA. What you have to do is what? I just said it, 2 words. Interactive discussion. That's what has to take place there. Even though the leave of absence time frame has run, it has come and gone, that is not the end all and be all of the discussion and the protections. The employee may need another 3 months of leave. Well, that may be something the law says is reasonable. It's going to depend on the outcome of that interactive discussion. And if after talking to the employee and analyzing the employer's situation, 2-3 more months can be granted, they have to be. That would be considered an extended leave and a reasonable accommodation. Because once it's established that something reasonable can be done, again, it's unreasonable if it poses an undue burden. But barring that, it's reasonable. Once there is a reasonable accommodation, that employee's status takes on a different connotation. They are now not solely or simply disabled. They are a qualified disabled employee. Qualified meaning that they are protected by the law and cannot be terminated. That there is an accommodation that's reasonable, that will likely permit them to return to their job, albeit another few months off work. That is one of the most confusing and unsuspecting problems employers face when they're dealing with a leave of absence. So remember, the focus of this alert: leaves of absence can become reasonable accommodations and therefore be mandatory under the law beyond the statutory required leave of absence. Okay, I hope you found this information informative. Stay tuned for another Holman HR video alert. Bye, everybody.